Welcome everybody to our presentation this evening. So your loved one can no longer care for themselves. Now what? Presented by Sara Kearsley from McKean Knaupp, and I'm going to let Sara continue talking about herself and the presentation. Thank you for joining us tonight, Sara.
Thanks, Amy. Like Amy said, my name is Sara Kearsley. I work at a small law firm here in downtown Hillsborough, and my primary areas of practice are estate planning, probate, and protective proceedings. And I've been practicing in those areas for 11 years here in Hillsborough, and I really enjoy the work. I enjoy my clients. Um, it's good work to do. So I'm going to jump into the presentation and just let you know, if you have any questions, feel free to enter them in the chat box or the Q&A. Amy's going to help keep track of those for me. As I go through the presentation and answer your questions, just remember that I can only give general information. I can't give legal advice. So if it's a very specific question, I may not be able to answer it, but I'll do the best I can. So your loved one can no longer care for themselves. Now what? My disclaimer, I gave this presentation as a practice to my 9-year-old niece last night, and she made it through 4 slides. So hopefully you all enjoy it a little bit more than she did. I think it's really interesting. There's lots of different circumstances where we need to help a family member. When I have a client that comes into the office, the first question I ask them is, did your loved one execute estate plan documents while they were capable? So the primary documents that I'm looking for when I ask that question, the first one is an advance directive. The advance directive appoints a healthcare representative, and that person can make medical decisions when the individual can't make their own decisions. It's not 100%. The healthcare representative can't do everything, but it can go pretty far to get you to be able to help your loved one make doctor's appointments, talk to their doctor, help them to make decisions. You can go pretty far. The next document I look for is a power of attorney, which names an individual, the agent or attorney in fact, to manage somebody else's assets or finances. And then the third document that can sometimes be helpful is a trust. So even if we have these documents, we still might need to go on to a protective proceeding with the court. But if you have someone in your life who's maybe moving in the direction of needing more assistance, but they still have capacity, still have understanding, if they're able to sign these documents, especially the power of attorney and advance directive, it can take you pretty far in getting a lot of work done for them. So if you can't, if you have a minor child who needs assets managed for them, or if you have a minor child who has special needs, they're not going to be able to understand and sign any of these documents, or if you have family members that are already past this point and there's no way that they can sign the document, that's what we're going to spend the most of our time tonight. And that's talking about protective proceedings in the state of Oregon. So there's 3 primary types of protective proceedings. And I'll add in different states do this differently. For example, my understanding is in California, they just have a conservatorship and it covers everything. In Oregon, we break it down into 2 different areas. The guardian is a person that can make decisions about a protected person regarding that person. So their health, they can talk to doctors, they can decide where the person lives. You're making decisions about the person. A conservator makes decisions about that person's money. So the conservator only manages the assets, the guardian only manages the person. Oftentimes they're the same person. Oftentimes we'll get a guardian and conservator appointed through the same process, but they're very separate roles. The third type of proceeding is called an other protective order, and it's really not used very often, but it can be helpful if you have very specific circumstances and one specific task that needs to be done. And nobody has authority to do it, so we need to ask the court for authority to do that. One example I have of an other protective order is I had a case where a son had a power of attorney signed by his mom, but it didn't allow him to sell her house. And so we didn't want to do a conservatorship because he had authority to take care of the bank account as a power of attorney. And so we went to the court and got another protective order that allowed him to sell mom's house. We put all of the money in the bank account and then closed the protective proceeding. So the court didn't have any kind of ongoing maintenance or supervision. And my client was able to just manage the account as the agent under power of attorney. So it's very specific. Like I said, we don't do it a whole lot, but sometimes it can be useful. So one question that I get with these on occasion is, can I do this on my own? How much is it going to cost and why should I pay an attorney to do it? With the guardianship, you could potentially do that on your own. There's very specific rules and steps, which I'm going to cover in a couple of slides about how to get a guardian or conservator appointed. And if you miss any of those steps, then you're going to be at square one and you're not going to get anything done. So I think it is really helpful for any of these to work with an attorney to get guardian conservator appointed. Once a guardian is appointed, I think it's very fair for you to have the attorney withdraw from the case, and a guardian can certainly continue forward and do things on their own. With a conservatorship, generally, you do need to have an attorney on the matter and helping you with the accountings every year and going through that process. And other protective order, I'd say the same because they're so specific, you're going to want an attorney to help with that. So let's talk a little bit more about a guardianship. In order to have a guardian appointed, we must show that the individual is either incapacitated or a minor. And this is the definition of incapacitated taken from Oregon law. It's called ORS Chapter 125, defines and tells everything about guardianships. Essentially, in order for a guardian to be necessary, we have to show that the individual can't take care of themselves. And they can't take care of themselves to the extent that it's going to potentially cause injury or illness. That doesn't mean we don't like the decisions that that person is making. One example that's brought up often is homelessness. If somebody is living on the streets and that's their decision, and it might not be perfectly safe, it might not be perfectly good situation, but they're making that decision and they're able to, then that's not need for a guardianship. If a person is homeless because they don't have the ability to make decisions and there's mental illness or other issues involved that are making it so they don't understand what's going on around them, then we can go to the court and ask for a guardian because they're incapacitated. So it's very fact specific and very circumstance specific. We look at every case individually. Minors are a little bit easier. A minor is any person who's not attained 18 years of age. So we don't do minor guardianships a lot, but we do have cases where maybe a child has been living with the grandparent and the grandparent wants to add them to the health insurance, or we need to be able to talk to the school district or to doctors, and they won't do that without the official guardianship papers. A lot of families will just make arrangements because it works for the family, but in order to be official, you'll need to do a guardianship. And there are, with the minors, there's additional rules that we have to follow and additional information to provide to the court that's covered under a different chapter of Oregon law. So we have to follow Chapter 125 and Chapter 109. And I won't go into detail about that, just know it's a possibility and we just look at it a little bit differently if it's a minor, but we can certainly do that. And then if we have a minor who's turning 18 and that minor has some sort of disability or special needs where they're not going to be able to take care of themselves or be independent at 18 or even 25, 30, they're definitely going to be dependent. We can petition the court for a guardianship of an adult up to 90 days before that individual turns 18. In that case, the guardianship is only effective after the individual turns 18, but we can have it in place for them. So conservatorships, we have to show that the person is financially incapable or a minor, and we need to have assets to be managed. So a lot of times we'll just do a guardianship because the person doesn't really have any money, so we're just not even going to worry about that piece. If we're talking about an individual who has supplemental security income, SSI, they're getting paid through Social Security, but we're not really accumulating, then there's other ways to manage that money. Or if we have a person that has a power of attorney, maybe we do a guardianship. We're not going to do a conservatorship because the agent under power of attorney can manage everything. But with a if we do need a conservatorship because we have assets that need to be managed, the person needs to be financially incapable. That means they can't make decisions. They can't take care of their finances. One example is if you go to your uncle's house and there's stacks of paper everywhere and you're finding uncashed, undeposited checks in his recycling basket and you're finding bills that haven't been paid and shut-off notices for utilities, that's an indication that maybe they need a little bit of help with their finances. So we would talk about if that meets the financial incapacity standard at that point. So guardianships and conservatorships are separate, but they have a very similar process. Before I jump into the process, I want to make sure to define a couple of terms. When I talk about a petitioner, that's the person that petitions the court or asks for a guardian to be appointed. The respondent is the person that needs a guardian or conservator. They're responding to the petition. When a guardian or conservator is appointed, then the respondent becomes a protected person. And throughout the rest of the proceedings, they'll be referred to as the protected person. And then obviously we have guardian and conservator. Sometimes the court will refer to that person as a fiduciary because they're making decisions for somebody else. So to start a protective proceeding, the petitioner files a petition with the court that gives information about why we need guardian, what's going on with that person, what the concerns are. We'll give information about the respondent, about the petitioner, about the proposed guardian. The petitioner and proposed guardian are often the same person, but they don't have to be. If you want to petition the court to have somebody else be the guardian, we can certainly do that. And we'll just lay out all the information for the court. And the idea is that they have everything in front of them that shows the person's incapacitated and that we have someone that can be a guardian for them. Once we file that with the court, they're going to assign a case number, and then we're going to prepare our notice to the respondent and to others. So any respondent who is 14 years or older has to receive notice of the guardianship or conservatorship, and it has to be served to them in person. So we have a process server that will go to the house and deliver the paperwork. In addition to the notice, which is pretty extensive and outlines what a guardianship is and what we're asking for, who we're asking to be appointed guardian, we lay it all out in the notice. And then the respondent will also get a copy of the petition and they'll get an objection form. The objection form is printed on blue paper, so it's really easy to spot, and it's really easy for the respondent to check a box that they don't want the guardian, sign it, and get it to the court. But it's intended to be a really easy process to object to a guardianship. For the other people, it really depends on the circumstances who gets notice. If there's a spouse, they'll get notice. Adult children, anybody who's living with the respondent and interested in their affairs. So it can be pretty broad. If the respondent is receiving any kind of state assistance, Medicaid, SSI, anything like that, then the state also gets notice. So we have a list that we go through, make sure everybody gets notice. And then they have 15 days to respond to the notice and file an objection if they want to. Excuse me. If there's an emergency, we can't wait for 15 days to get a guardian in place. Something's happening immediately and we need to protect the respondent. We can shorten the notice period to 2 days and just get a temporary guardian or conservator appointed. And if it's even more immediate than that, we can do an emergency guardianship or conservatorship without any notice. We can go directly to the court and have the judge sign off on the judgment, and then we give notice within 2 days of that appointment. I've only ever done that once, maybe twice in 11 years. So we have to be really careful and prove to the court that there's an absolute immediate need in order to waive the notice period. So otherwise, in normal circumstances, we have these 15 days that we're going to sit back and wait. During that time, the court visitor for adult guardianships will go and talk with everybody. They'll meet with the respondent, the petitioner, the guardian, caregivers, family members, and the court visitor's job is to get a good idea of what's going on and then make a recommendation to the court as to whether or not there needs to be a guardian appointed and if the proposed guardian is the appropriate person. So this is only required for adult guardianships, but the court can do a court visitor in minor guardianships or conservatorships if there's a need to. I don't think I've ever had them do that. They can. So after we get through this process, we have our court visitors report. It's been 15 days. If nobody has objected to our petition, then we're going to submit the judgment to the court and wait for them to sign it. And then once it's signed, you're the guardian or conservator, or the proposed person is. If there's any objections, then the court will set a hearing. And at the hearing, we'll provide evidence as to why there needs to be a guardian or why there doesn't need to be a guardian. Oftentimes, the objection is more to who the proposed guardian is. We see a lot of cases where it's very clear we need a guardian, but there's different family members that want to be the guardian. And so we'll have a hearing to determine which one is more appropriate. New law in Oregon requires that the court appoint an attorney to represent the respondent if there's any objections in a guardianship. So that law right now is effective in Multnomah County, Lane County, and Columbia County, but it becomes effective for the entire state starting in January of next year. So if there's any objections, that the respondent will be entitled to have an attorney involved with the process and representing them. So if there's an objection, we go through the hearing. Oftentimes the judge will sometimes they'll say, I'm going to appoint a guardian, go ahead and submit your judgment. So we submit them again. Sometimes they take a little bit longer and they'll get to us. But either way, whether there's an objection or if we have a hearing and the judge still decides that we need a guardian, we submit the judgments to the court and then the court signs it. So here, slightly different process once we have guardians versus conservator appointed. With a guardianship, as soon as the court signs the judgment appointing the guardian, they're going to issue letters of guardianship. And then the guardian has 30 days to provide a notice of appointment of the guardian. And that's another new law. It's been in place for, I think, 2 years. And that notice has to be given directly to the respondent, who's now a protected person, by the guardian, and the guardian has to read the notice to them if the protected person wants it read. And then we file all that with the court and prove that we did it. In some counties, they also require that the guardian take a fiduciary class, which can, I believe it can be taken online. Before COVID, they required it to be in person and only offered online in very narrow circumstances, but I don't think they've gone back to that since COVID. I think it's still just online if if you need to take it. In the metro area, Clackamas County and Multnomah County both require the fiduciary class. Washington County does not at this time require it. Once you get through that, then you just make sure you're taking care of the person. You can step in, give the letters of guardianship to whoever needs to know that you're the guardian, their doctor, caregiver, if they're in a care facility, any of that. You'll want to make sure all the right people have a copy of those letters. And then every year you're required to give a report to the court. With a conservatorship, it's a little bit more complicated. When the court signs the judgment appointing the conservator, they're going to do it one of two ways. Either they're going to require that the conservator have a bond, or they're going to restrict the assets. If the assets are restricted, that means the conservator can't access them, can't take any money out of the bank account, can't sell the house, can't do anything without prior court approval. We restrict assets if there's no intention to sell any of the property or there's no need to access it, we'll restrict the assets. Sometimes if our conservator can't get bonded, then we'll restrict the assets. But we have a conversation with our clients about whether it makes more sense to restrict it or to just do a bond. The bond is essentially an insurance policy against the conservator doing something wrong. So if the conservator does something that causes the conservatorship to lose money when it shouldn't have, then the bond will step in and make the conservatorship whole. And then the bond company goes after the conservator to get paid. So if the court orders a bond, we have to complete the bond paperwork, file it all with the court and get court approval. And then after the court approves the bond, they'll issue the letters of conservatorship. So unlike the letters of guardianship, which we get right away, the letters of conservatorship can sometimes take a month or two after you're actually appointed as the conservator. And then again, you're going to be required to take a fiduciary class in some counties in Oregon. And also in all counties in Oregon, the conservator is required to file an inventory of all of the conservatorship assets within 60 days of being appointed as the conservator. And then you go on, manage all of the money, take care of all the income, and every year you'll report to the court what's happened in the accounting. So, I feel like I'm going through this really fast, so if you have any questions, feel free to stop me. Once you're appointed the guardian, I call these the highlights of your duties. I have a much longer paper that we hand out to our clients. And if you take the fiduciary class, I think it's an hour or two that they're going to be reviewing what you need to do as guardian and conservator. But here we're just going to kind of summarize a couple of things. First, you do need to file a guardian report with the court, and they do track that. And if you don't send it in, they're going to start sending letters and potentially set a court hearing to explain why it has not been filed. And they will review that. If they have any questions about the court, then you'll get a letter from the court asking about specific questions and your answers. So it's important to make sure those are done and to make sure they're done accurately. It is a form that's intended for non-attorneys to complete. You can find it online. The court, I think most of the county court websites have their form on there, and you just fill in the information. The report includes things like where the person's living, if they've been hospitalized, if they ask the question, does this person still need a guardian? And why do they still need a guardian? So you'll just give a little bit information about the status of the person. So as the guardian, you're going to make healthcare decisions for the protected person, and you're going to make sure they're taken care of, they're in a safe place, their living circumstances are appropriate. I really love the fourth bullet point down. This is from the statute. You're supposed to promote the self-determination of the protected person. So as you're making decisions for this person on behalf of this person, you want to involve them as much as possible and to follow their wishes as much as possible while still keeping them safe and healthy. You are supposed to um, make sure that they're keeping their relationships ongoing and identify and facilitate supportive relationships. You can, as the guardian, limit associations with certain individuals, but do that very carefully because if you do it when it's not appropriate, then you could potentially be removed as the guardian. And you see there's a question. I can't click on it because my screens are funny.
The question is, can both parents be co-applicants for the guardianship?
That's a great question. And the answer is yes. Um, in the past, I always take that with some caution because in the past, at least in Washington County, the courts have been pretty hesitant to appoint co-guardians because if the guardians don't agree, then the court ends up having to decide who's the right one. But my experience in recent years, and especially if we're talking about parents that are petitioning to be co-guardians for, a minor child that's turning 18 and needs ongoing care, the court's been more than willing to do that. If both parents are appointed guardian, they're both going to have to sign the guardian report. They're going to have to file it together. They're both responsible. They both have all of these duties and have to do everything and respond to the court. It's pretty equal. And if there's any disagreements between co-guardians that can't be resolved between them, oftentimes the court's response is to remove both of them and put in a third party. So is there another question?
Yes, another question came in. My mom is in Washington. Our intention is to have her sign all the forms before she deteriorates and move her down here once she needs my help. But my grandma, her mom, went fast and my mom couldn't get her to sign power of attorney in time. If this happens to my mom, where will I have to apply, in Washington or Oregon?
So if you're, it's a good question. And it kind of depends on circumstances. So again, speaking generally, if the respondent is in Washington, you need to petition the Washington court to be appointed as the guardian. And then as that guardian, you have authority to move them to Oregon. And then we close the Washington guardianship, open the Oregon guardianship. We go through, there's a process for transferring guardianships between states, and we can do it that way. If your mom is, or if a person's living in Washington and you convince them, hey, come back, come down to Oregon, come live with us. We found a great place for you. And they come willingly, and there's no need for guardianship in order to get them here. Then I would recommend just waiting until they're settled in the place where they're going to stay and just petition for guardianship in that state instead of doing both states. So it really depends on the person and their capabilities and what decisions they're willing to make on their own before you have to step in. Is there another question?
There is another question. So I want to know if the guardianship and conservatorship applications can be combined together.
Yes. So when I meet with clients, we'll talk about the guardianship piece and we'll talk about the conservatorship piece. And if there's a need, we'll do both of them at the same time. And it's just one notice period, one petition, one court visitor's report. The respondent will actually get two separate objections and objection forms because they can object to the guardian or object to the conservator or object to both. And when we do our judgment, it will be signed separately. There'll be a judgment for guardian and a judgment for the conservator, but the process can be all at once. All right, I don't see any more questions. So I'm going to jump back to the duties of the guardian really quickly. One important thing to note is that you you can make the decision to move the protected person. You don't need court approval for that, but you do have to give notice to the court and to the protected person and occasionally to other people if you intend to change their residence. I always tell clients, if you're going to move somebody, if it's an emergency, move them and take care of them, make sure they're healthy. If you have an intention and you're looking for a place and you have time, we're supposed to give the court 15 days notice before the actual move. But the priority is to make sure that person's safe. So don't worry about the notice if we need to move them for safety. And then the last little bit on here, some decisions do require court approval before you can take them. The most common one I see in guardianships is if we have parents that are acting as co-guardians for a child that's just turned 18, and now the child is getting Social Security, and the Social Security caseworker tells mom and dad, you need to charge for rent because then they'll get more Social Security. You can't do that. You can't get paid without prior court approval. If you're the guardian, you need to get permission to pay yourself out of the protected person's funds. So that's the most common one I see in guardianships, but there are a few other really small things that you might need to get prior court approval for. And so an attorney can help you understand and know that. Duties of the conservator, pretty similar to the guardian. You're going to take care of the person's assets, make sure you're paying their bills, make sure that they're taken care of. Depending on the level of capacity, I've done conservatorships where the conservator gives the protected person a monthly allowance and they get $500 every month to just blow on whatever they want to blow it on. But we're going to keep the bulk of the money safe from scams and from other issues that might come up. So the conservator is going to take possession of all of the property of the protected person and their income. They're going to set up a separate bank account that's owned by the conservatorship. They're going to file an inventory of all conservatorship assets with the court. It says within 90 days, but I believe it's actually within 60 days. And it's 90 days in a probate, 60 days for a conservatorship. And then every year you're going to file an accounting with the court. And as I said earlier, this is something you really want to work with an attorney to make sure it gets taken care of. I've had multiple clients come in because they tried to do the accounting and they ended up in front of a judge and the judge said, go find an attorney. So then I step in and we try to get it all taken care of correctly. The other thing with the conservatorship, you need to be careful with the investments. Usually we advise clients, especially if it's a large amount of money, to talk to a financial advisor and get them into low risk investments. You don't want to just have everything sitting in the bank necessarily, although that is certainly appropriate in some cases. And you'll also need to make sure tax returns get paid if that is necessary. And just like with the guardianship, when we have a conservatorship, some decisions need to have prior court approval. The example I listed here is that if you want to sell the protected person's primary residence, for example, if mom is going into a care facility and there's no way she's going to return to home ever, then we need that to sell the house to pay for her care, then we'll petition the court for permission to do that. You can't just do it on your own. The other big one that happens in every conservatorship is you can't pay attorney's fees out of the protected person's money without getting prior court approval. And I will mention, since I already said you need to have an attorney in all of these cases, Oregon law allows you to pay attorney's fees from the protected person's assets if you get prior court approval, which is pretty standard practice. That's what we do in almost all of our cases. There's a conservatorship, often with guardianships, but not all the time. So, any questions before I move on? Okay. My last slide is about terminating the protective proceeding. And I wanted to include this because I want to make it clear that Oregon state law says that we want to recognize that this is a significant restriction on personal liberties and only use guardianships and conservatorships if we absolutely need to. So if there's something we can do before or instead of a protective proceeding, we have to look at those options and consider them. If a person is subject to a protective proceeding and they've improved and have capacity now and they're doing well and they're able to make their own decisions, then we would want to terminate the protective proceeding. So in Oregon, when I very first started practicing, we would commonly talk about permanent protective proceedings as opposed to temporary protective proceedings. The court doesn't like that term. We don't use it anymore because they're never permanent. They're indefinite because they can be terminated at any time. With a minor guardianship, the guardianship will automatically terminate when the minor turns 18. You don't need to do anything. The court just takes care of it, closes the proceeding, you're done. If we have a minor conservatorship, the law says it terminates when the child turns 18, but the conservator generally will need to file a final accounting and ask for court approval to distribute the assets to the now 18-year-old. And especially, we often will do restricted assets for a minor conservatorship. So the conservator won't even be able to write a check without court approval. So we need to go to the court and get permission to do that. But the good news is when the 18-year-old is now an adult, they can waive the right to the accounting. We can make it a much simpler and faster process to close out that proceeding and get the money to the adult. With an adult guardianship or conservatorship, the guardian or conservator could ask to terminate it. The protected person can ask the court for termination. Anybody else can step in and ask for termination, and anybody can object to the termination. And I have had cases where the protected person is writing letters to the court every week and telling them that they don't need a conservatorship and they don't need a guardian and they're perfectly fine. And in the one case I'm thinking of, the court sets a hearing about every 2 or 3 months, and we go in and show evidence as to why that should not be terminated. But again, in some cases, that person does have capacity and they shouldn't have to live under the guardianship and conservatorship if they're able to take care of themselves. And then the last circumstance is that protective proceedings will automatically terminate when the protected person dies. But again, with a conservatorship, we have to file a final accounting to the court, and then we'll ask for permission to distribute any assets remaining in the conservatorship to the right person, which is often the estate of the protected person. I didn't include this on my slide, but I will say I've had a couple of times where we terminate a conservatorship because there's no more money left, but we keep the guardianship in place. So that's another circumstance for termination. And I think I covered everything I wanted to cover. Are there any other questions? Okay. Well, if there's no questions, here's my contact information. I'm happy to talk to anybody, answer additional questions. If you want to do a consultation for a guardianship or conservatorship, I'm happy to do that as well. And I'm good with giving just general information over the phone if you just have 1 or 2 quick questions that aren't specific, but more general information. So feel free to reach out, and thanks for listening.
Thank you, Sarah, for all that wonderful information. And thank you, everybody, for joining us tonight. For anybody who is interested, our next legal information series is going to happen on November 8th, 6:30 again, and it's going to be, so you have a dispute with your contractor, now what? I am going to stop the record. It does look like we have another question. But if anybody wants to ask any other questions not on the record, feel free to stick around and we can do so.